Thank you. Next we have Eva-Clarita Pettai.
So I will actually use PowerPoint. Let me see. Yes, in the hope that because I'm using a number of tables, and so I think things get clearer. I need to also. How do I? Here. So the aim of my paper originally was, and that was why there was confusion over the title, was to present you a conceptual model for mapping out the entire spectrum of transitional justice measures in post-communist context. However, given the title of this panel and also discussing this with the organizers, I realized I should talk about the countries that I have applied this model to, which are the Baltic states, Estonia, Latvia, Lithuania. And so what I will do now is present you more briefly with a conceptual model that maps out transitional justice as an analytical tool to understanding the politics of truth and justice, to then apply it to the Baltic states and present you some of the results, and to show you how this model allows you to indeed identify the patterns of truth and justice in concrete countries. This one is it. So jumping straight away to the kind of matrix of truth and justice, this is built, and I've gone into detail how we arrive at this model. This is basically based on the two basic analytical parameters that you can find in the literature on transitional justice, one being between perpetrators and victims, and the other being between, already dating back to Neil Critz and others, the differentiation between criminal and non-criminal justice. However, looking into these two dichotomies, we realize that on the criminal, non-criminal axis, the non-criminal is actually rather vague on what exactly it entails. And so we decided to further differentiate the non-criminal, the kind of the substantive part of transitional justice measures, into political, administrative, and symbolic representational measures. And this allows us to then map out the entire spectrum of truth and justice measures that countries have, and really make sense how they relate to each other. And surprisingly, this has never really been done in this way. There have been few efforts, Grodzki is one example, to really conceptualize the, let's say, dependent variable, the transitional justice, truth and justice processes as such. And so this allows us then to differentiate, to actually disaggregate lustration measures into those that involve administrative, political mechanisms such as purges and vetting procedures, office bans, etc., and those that involve more symbolic processes such as, mechanisms, truth revelation mechanisms of voluntary self-reporting with the kind of counter procedure of public shaming or disclosure of names in case people don't admit themselves to their involvement with the secret police. And on the victim side, it allows us to clearly differentiate between measures, rehabilitation measures that clearly involve the judicial criminal system of restoring individuals' legal records, and those that involve more administrative procedures such as compensation measures, as well as property restitution. So in that sense, you have a beautiful initial matrix here that allows you to then have a whole overview of a country's truth and justice measures and processes that can take place. However, what we also realized in developing this is that there are actually two temporal dimensions involved in this matrix, and this you also find in the literature a lot, the different temporal dimensions of transitional justice. The one that we decided to literally integrate into the matrix, or we basically tried to integrate both of these temporalities into the matrix. The first one being a differentiation between transitional justice or truth and justice being more the understanding of the conventional understanding of justice carried out in the more or less immediate aftermath of regime transition, aiming at perpetrators and victims of the immediately ousted non-democratic regime, and very much aimed at locking in the democratic transition. This is sort of the conventional understanding. But then there's a different one, and this comes into play mostly in countries that emerge from extended dictatorships, not just the post-communist, but there are also other examples. And they deal with crimes that often have taken place many decades earlier, such as, like just as you just heard, in Central and Eastern Europe, mostly right after the war or during the war. And nevertheless, countries coming out of this authoritarian extended dictatorship deal with these retrospective truth and justice issues as well. And so it becomes interesting if we integrate them within one model of what the political dynamics are for elites to decide whether to engage with more retrospective crimes or more recent. And indeed show the dynamics of the political dynamics involved in here, that, for example, countries may opt for going more for the more distant crimes in order to avoid having to face the more recent wrongdoings, or things like that. But there's another temporal dimension that merits to be also included in the kind of conceptual model of transitional justice, and that is the post-transitional, what has been tried to be coined as post-transitional justice more recently. This, of course, concerns what has been much talked about in the literature on transitional justice, the changes or newly introduction of measures of redress and accountability long after the actual transition is over. Now, one could go into detail on how to define transition and when is transition over, etc. I'm not going there, but what is important here when we are interested in the politics of truth and justice is that decisions on truth and justice measures in this kind of post-transitional context are significantly different. The elites are acting in different political, attitudinal, institutional contexts, so the politics involved in this kind of truth and justice is different from that in the immediate aftermath of regime change or in the middle of regime change. So now, trying to integrate all of these different dimensions and measures into one matrix, we arrive at this. And of course, what is important to point out is that the second temporal dimension, the post-transitional, is very difficult to depict in visual form. And so one has to actually imagine that as if there's sort of a landscape, a three-dimensional landscape for each of the individual cells. And the question is then, how do you measure the intensity of a particular measure, or how do you show how measures are ended or decrease in intensity? Then the kind of a landscape evolves, and I will show you how I try to depict this in visual form later on when I turn to the Baltics, which I will do now. Now, just briefly, this kind of differentiation between retrospective and transitional allows us again to nicely not just differentiate, as I said before, between different measures of lustration, but it also has the beauty of, on the symbolic representational side, it allows us to differentiate between, for example, truth commissions that are concerned with a more distant past, and those historical commission usually called, and those that are concerned with the more recent crimes and abuses. But this is just one of the many benefits that you get from really differentiating between historical crimes or retrospective truth and justice processes and more transitional one. Now, moving to the Baltic states, because we don't have much time and I wanted to talk about these three cases. The panel being about specific regional specifics, one has to, of course, acknowledge when looking at truth and justice processes in the three Baltic states that there are certain specific features of these countries that are perhaps different from other Central European post-communist countries, such as the historical factors, Baltic states being the only Central European countries that had been literally part of the Soviet Union, thus more imminently affected by Stalinist mass terror, deportations, etc. During the war, before the Germans even came, and right afterwards. Moreover, the historical, the particular historical circumstances, determine, of course, the approach Baltic states took to truth and justice measures after 1991, where they framed their restitution, their state independence as a form of restitution, as a legal continuity, and the entire period of Soviet rule as an illegal occupation, which of course very much informs then the legal criminal frameworks they developed also for punishing perpetrators or restituting property or redressing victims. The historical circumstances, of course, have also demographic legacies that are crucial because they also affect, of course, decisions on truth and justice, meaning that especially in Estonia and Latvia, large parts of Russian-speaking migrants, Soviet migrants, remained in the countries, and they often are associated with a whole different narrative, a more Russia-oriented narrative and questioning this legal continuity paradigm very much. So, talking about discourses of truth and justice measures can be easily securitized in internal domestic relations, as they can in international relations. Of course, the geopolitical situation of the Baltic states, with Russia very closely monitoring any kind of truth and justice processes, also very much affect the outcome here. But be that as it may, there might be very specific features here. It doesn't matter, or it doesn't necessarily mean that we're dealing here with some sort of exceptionalism and they cannot be compared to other Central European countries, which they can, I think, and I think our model very much helps in that respect. Now, summarizing, because I know the time is coming up, summarizing briefly across these three substantive categories of transitional justice that are outlined in our model, the patterns that emerge in the Baltic states, one can say that on the level of criminal judicial truth and justice, we see that all three states predominantly focus on retrospective, retrospective truth and justice, meaning on the crimes of Stalinism, on developing legal framework that define these crimes as genocide or as crimes against humanity, and really going after the 85-year-old former NKVD agent who has been involved, who signed the orders for mass deportation, who have been involved in torture and other human rights violations. There are, however, huge differences between the three states in terms of scope, how far they go, whether they include, for example, anti-partisan acts, post-war crimes, and also in severity, how strictly they actually apply the genocide definition, legal definition in the different cases. Here we see clear differences between Lithuania on the one hand and the other two Baltic states. Lithuania punishing literally every person who has killed a single partisan after the war as having committed genocide against the Lithuanian people. On the political administrative level, we have to differentiate, of course, between the perpetrator and the victim side. We see a strong focus, just like in other Central European countries, on KGB on former KGB employees, agents, less on informants or going, further and broader. And here the measures have been, again, varied in terms of defining, or in terms of what they aim for, punishment or truth. With Estonia going actually the most lenient in terms of going after these people, merely seeking to identify them and perhaps publish their names if they don't admit voluntarily, but I will go into these details maybe if I have the fine. So there is a difference in this particular area. And on the victim side, in terms of redress and restitution of property, all three states are again historically determined retrospective. It's about property that had been nationalized in 1940, that has been comprehensively restituted, especially in Latvia and Estonia, a little bit less so in Lithuania, and redress measures, compensation measures for victims also concern mostly former deportees and political prisoners of the 40s and 50s and resistance fighters. They differ here in terms of timing. Lithuania starting much later, being more close to Poland, where an early illustration law did not go through, and only with the return of the center-right political parties to power did the illustration law be passed in '96. And both Estonia and Latvia having very early on measures of vetting and to some extent office bans, but very limited. On the symbolic representational, one can summarize that they are also predominantly retrospectives, thus focusing again on the victims of deportations of political imprisonment during the 40s and 50s, focused also in Lithuania, especially on the post-war partisan struggles. And measures here are, that is important to point out, both collective and individual. Thus, they are, truth-seeking efforts. Commissions seek to determine the scope of suffering of the entire nation, as well as their individual level truth-seeking mechanisms in place, such as individuals being able to look into their files on the transitional justice part, or individuals telling their stories, being recorded, giving testimony about their suffering in the 40s. Now, to give you an idea of how this would then look like, if you look at the, let's say, landscape of truth and justice, these are sort of quickly, I don't know whether I can now go back again. How do I go back? No, how do I go back? How do I go back again? There? Maybe there? Yes. Okay, that's good. So you see, in both Estonia and in Latvia, you have rather light colors. And we try to now show in different gray shades, the kind of three-dimensional landscape that emerges. So you have, for example, on the criminal judicial retrospective box, right on the top, on the top left, you have a darker shade in the beginning where the legal frames are set. The law is passed in Estonia only in '94 to define crimes of deportations and other mass crimes of Stalinism as crimes against humanity, including genocide. And so first legal charges are brought and trials take place. And then it fades out with no new trials actually taking place. There's a change of the legal framework when the new National Criminal Code is actually passed. Before that, it was just an amendment to the old Soviet. You have a similar picture in Latvia. However, you have a much more radical break, because you see intense investigations and also charges and trials in the late 90s, and then it suddenly ends. Some trials still take place, but there are no new legal charges brought, no further investigations done. And the main reason for this has been or can be found in different things in investigatory infrastructure and others, but mainly in the legal framework context, because with the new criminal code in Latvia, they did not provide any offense of crimes against humanity. But if the prosecutor wanted to actually charge somebody for crimes committed under Stalin, it had to be genocide, and that was very difficult to prove. The kind of genocidal intent that is inherent in that was difficult. So one reason why Latvian prosecutorial activity goes remarkably down is because of changes in the criminal law. Now, others, like the dark line there on the lower the box, what is it, 3B, is an effort by the Latvian parliament, for example, to throw open the KGB files. And they even passed that law, and then it is vetoed by the president. But it is an attempt to indiscriminately just open the files and make the names public without further, restrictions and explanations. So this is then marked also as dark. So suddenly it goes up and then it goes down again because it is vetoed. So just to show, these are sort of examples Lithuania really strikes you when you look at it that it's not only darker in most of the boxes than the other two, but also that intensity is actually increasing towards the end. That, you know, in terms of criminal judicial justice against perpetrators, where Latvia, you know, also because of the economic crisis, is actually scaling down, closing institutions, really reducing the investigatory capacities of the Prosecutor General's office. Lithuania is putting additional money into it, employing additional people to go after the last surviving NKVD officials or MGB officials who were involved in partisan fights after the war. And the same you see on the symbolic representation on the victim side. Lithuania tends to go further. It's more intense, more institutionalized. There is hardly a month passing without Parliament, you know, adopting a resolution that declares somebody immature or declares a certain event important for national memory. So there's a lot of activity here. The scope of victims, the definition of victims, is extremely broad. So eligibility to compensations is much broader than in the other two. Okay, so coming to a conclusion, we have identified 3 patterns, indeed, you know, representing each of these countries. First, we have called that the kind of the hands-off approach to truth and justice, which you can see in Estonia, which we have defined as the state provides a minimal legal, administrative, and infrastructural frame to facilitate truth and justice processes, and yet it does not invest much of its resources, leaving much of the struggle for truth and justice to non-state actors to then compete for public funds. And on the other extreme, you have a pattern that emerges as what we call the hands-on approach, which is more the Lithuanian one, where the state provides a very strong legal framework very early on, you know, defining these crimes as genocide and as crimes against humanity. Also administratively and institutionally, the infrastructure is very strong to research, to undertake truth-seeking, and to supply the prosecutor with material to facilitate truth and justice. And then the state also seeks to very much lead the process through institutional, legislative, and financial means in all of the various realms, and that you could see the black or the very dark shade there. And then so you have the hands-on and the hands-off approaches very much. And then in the middle there is something that, and for some reason Latvia always ends up in the middle, but that what we call the ambivalent state, where you have certain infrastructure, institutional settings, legal frameworks in place. They are actually quite strong. You have a special center for the analysis and research into the historical crimes, working very closely with the Prosecutor General having an own subdivision only concerned with historical crimes, etc. And yet then there is no money put into that. The staff is heavily understaffed, it's old people, and it's extremely work intensive to go after these historical crimes. So it's hardly possible for them to really show. And you see that in the numbers are extremely low in Latvia when it comes to charges and actual trials. But you see that kind of phenomenon across the different boxes of our matrix, that yes, the framework is there, and yet somehow the political and financial support is missing. So you have a much more of an ambivalent approach here. This is, of course, beautiful to then apply now to all sorts of other post-communist countries, and one would then see what kind of patterns emerge. Eventually, this kind of ambivalent state approach might be subsumed to the hands-off approach. It can be a sub-variant of that. I can imagine you could find also a pattern that is more sort of a total non-involvement of the state, which we don't see here. But for now, for these 3 states, these are the kind of patterns that we have identified, and of course the next step would be then to move to a full-scale kind of typology of truth and justice in post-communist countries. Thank you very much.